Welcome, everyone. And on behalf of Katie Connell, who co-chairs this subcommittee, I welcome you and appreciate you being here. There have been so many times previously when we could not move forward because we only had one or two, or sometimes nobody, it seems like, show up. So I appreciate it more than you know. I know everyone's busy, and actually, we moved this to Friday afternoons because we thought people don't normally schedule things for Friday afternoons. And I know that seems terrible. It's like, who would do this on a Friday afternoon? But that's the reason why we had to do it, is because we know everybody is so busy during the week, and that sometimes folks don't schedule things on Friday afternoon. So we thought maybe that will leave some availability. We'll try to get through this agenda as quickly as we can, because I do realize that it's July and it's Friday afternoon. So we're going to move through this quickly, hopefully. Noelle, if you will, please do us the honor of introducing Joanna Deering, the new staff attorney for the Georgia Child Support Commission and new assistant division director for communications, children, families, and the courts at the Judicial Council, AOC.
Yes, my pleasure, Judge Williford. Thank you. So I believe most of you know via email, I know at least the commission members were notified that, I've personally served as assistant division director, and along with that role comes the honor of being the staff attorney to the Child Support Commission. So I've done that for just shy of 6 years, and I'll be succeeding our division director on August 1st when she retires. Her name's Michelle Barkley. She had a remarkable 30-year career at the AOC. But I'm thrilled to welcome my successor as assistant division director and your new staff attorney, Joanna Deering. I'm going to invite her to say some welcoming words of her own, but I will note that I love lots of things about her, but especially she's both a CPA and a JD. So I think in this role in particular, that's going to be super helpful. We often get questions, as you know, about what qualifies as income, questions about folks' tax return, how to handle the child tax credit, things of that nature. So I'm thrilled to have Joanna on board, and we welcome her. And Joanna, do you have anything that you want to say?
I just want to say it's a pleasure to meet everybody on the committee, and I'm looking forward to this. I've been a member of the Georgia Bar since 2004, and have practiced in the criminal defense arena and some family law. And I'm very excited about this role, but please be patient with me as I get to know everybody's names and the members. I'm trying to work that out for this meeting as we speak. Thank you.
Well, Joanna, let me say that we are thrilled to have you, and I look forward to meeting you and getting to know you better. And I'm sorry that I haven't reached out and already scheduled at least a virtual meeting with you. I've had a pretty hectic schedule of late, but we're happy to have you. And Noelle, I know we've already bombarded you with emails telling you how much we're going to miss you and how proud we are of you. But I will say personally, now that we're on this meeting, that Joanna, you probably already know this, you have big shoes to fill.
I know.
Noelle has been absolutely amazing. She's brilliant. She has the perfect temperament and patience and knowledge and all of the things that you need to deal with this role. And I know that you'll reach out to her with any questions, and Noelle, I know that you'll be happy to help Joanna as she transitions into this role. And we are so proud of you for being the division director, and you are certainly worthy of that. And I just can't say enough about how excited I am for you. And as much as we're going to miss you, I'm very proud of you. Anybody else have any words quickly for Joanna or Noelle?
I have to keep reminding myself that Noelle is not leaving me. She's only going down the hall. So that makes the transition a little bit better.
She's leaving you, Kurt. Don't let her lie to you. She's leaving us.
Well, she's technically my boss now, so that's exciting. No, we're happy as heck to have Joanna on board. She's been doing great so far.
Well, you know, we had to deal with the same thing when Elaine left us and we had Kurt and we were like,
Right.
there's no way anybody's gonna be able to do what Elaine does, but Kurt, you're doing a great job.
Thank you.
So we know it can be done. Change is hard, but we know that we can live through it because we lived through it last year. Has it been a year or has it been more than that?
When did she retire, Noel? Like,
March 1st, yep, of
first of
24.
last year.
Yeah, so a year and a
24.
half and
Yeah.
and we've made it and we've done well, I think. All right. Lazaro, will you give us our meeting rules for the members and how we will conduct the business virtually, including everything that our folks need to know?
Of course. Thank you, Judge Williford. Hello, everyone. I am Lazaro Quintanilla. I am the project coordinator for the Georgia Child Support Commission. I'll briefly discuss a few rules to help us navigate the meeting for today via Zoom webinar. The Statute Review Subcommittee meeting members and staff are designated as panelists within the Zoom and can speak at any time during this meeting. All other participants are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat feature if needed. The Child Support Commission does not hear public comments during any of its subcommittee meetings. Accordingly, we will not be accepting public comments today. However, you may leave a written comment for the Commission at any time through the Commission's website. For your convenience, in a moment, I'll post the link to that in the Zoom chat. Also, anyone wishing to give public comment by speaking may do so at any Child Support Commission meeting, the next of which will be August 1st. In conclusion of today's meeting, staff will post the recording on our YouTube channel, on the Georgia Child Support Commission. I'll also post a link to that in the chat in a moment. Thank you.
All right, Katie, I'm gonna kick it over to you.
Thank you, Judge Williford. All right, so first on our agenda is the minutes from the March 18th, 2025 meeting have been circulated. Hopefully everyone has had an opportunity to review those minutes. I would love to have a motion to approve those minutes or
So moved.
obviously entertain any proposed amendments. Okay, hearing a motion to approve them. Do we have a second on that?
Second.
Colbert.
Thank you. Let's do it this way. Does anyone dissent or not want to approve them? Okay, so we'll call that approved as a unanimous vote. Thank you, and thanks for taking a look at those. I believe we are now ready to move into the substantive business of the subcommittee. My agenda notes that we're starting with the possible recommendation to the Child Support Commission to amend OCGA 19615. We've got four categories of issue. The first being the removal of the 7% test, what we refer to as the 7% test in the deviations as a special expense of child rearing. Item number 2 is extraordinary expenses being handled outside of the worksheet. Think extracurricular activities and other enrichment activities that go into the expenses of child rearing. Number 3 is we've discussed at our last meeting, providing some guidance on high income deviations. And then number 4 is moving the dental and vision insurance premiums that are currently addressed by our guidelines as a Schedule E deviation, and giving at least the opportunity, if not a mandate, to treat those like we do health insurance premiums on Schedule D. As I think everyone knows, those 4 issues were brought before the full commission at our last meeting, and the commission tasked this subcommittee to discuss and research those topics further for potential legislation to be introduced in the future. So we have been officially tasked with discussing those issues. Assuming that it's okay with my co-chair, I think we should tackle them one at a time and start discussing them as a subcommittee.
All right, go ahead.
All right, so the 7% test. Hopefully, first and foremost, that's a familiar nomenclature for everyone. Any thoughts, comments, concerns?
Did we get any guidance from Dr. Venor on this? Refresh my recollection.
It is my recollection that Dr. Venor gave us the feedback that, and yes, so yes, she did present on the issue, and that she explained that the 7% test comes from a consumer expenditure survey that was conducted sometime between 1996 and 1999 by the Bureau of Labor and Statistics, that the categories that fall within the 7% from what's considered entertainment, and entertainment expenditures include fees and admission to sporting events, playing on teams, sports equipment, toys, playgrounds, video games, fishing equipment, boats, etc. The problem, as Dr. Venor reported, so I say that just to say it's not me that's reporting this, it was Dr. Venor, is that with respect to that category, the category is not it's not as plain and clear as just entertainment. And sorry, I'm just looking through my notes here. I'm trying to say this as efficiently as I can. Yeah, I got the impression, I would love for someone to disagree if you got a different impression, but I got the impression that Dr. Venor thinks that our sort of definition of that and what we're putting in there is very muddy, and that we're essentially probably not capturing what we mean to and capturing things we don't mean to, and that it's really not an economically sound thing that's in our guidelines right now, and that we definitely should be looking into changing it, at least to the extent that it is our goal to have the economic basis that we base our guidelines on be sound and consistent. Obviously, Dr. Venor does not wade into whether, if we should change it specifically. She leaves that up to us as, as the commission and then the legislature, of course. But I think she was pretty clear that that's probably not what we mean for it to be in terms of its implementation. Once she heard from us and knowing what was what went into that number, she also talked about entertainment expenses dropping down to 5%. And that I don't think Georgia is consistent with the other states and how they're applying it. And we're potentially, this is my interpretation of what she said, and my best recollection is that we're potentially not appropriately providing the financial resources for Georgia's children and sharing them between parents by doing it the way that we're doing it currently. Again, that was my interpretation of what Dr. Venor reported to us when we last met with her. Does anybody else remember what she said or have an opinion about it?
Well, I wasn't there because I think I was in trial, but did she have a recommendation? I read the minutes and it said something about, maybe some states are using 5%, but are there states that just aren't doing this at all?
Yeah, no, I think we're a major outlier. Isn't that your
Yes.
recollection, Katie? I think we're
Yes.
like one of maybe us and Tennessee are the only ones that are doing it.
Right.
It's
And-
always seems so confusing to me, and I'm not sure that I understand it, but I believe I do. But I've had challenges with other attorneys who were like, wait a minute, what are you talking about? And trying to explain to them. And then, there'll be clauses that I see all the time in settlement agreements that say, the parties are going to split extracurricular 50-50, and I'm, or whatever. And I'm like, well, what about the 7%? And they're like, what are you talking about? So, I mean, I've always found it very confusing, and I guess the question is, is it an option to just remove it altogether? And then any sort of deviations for special expenses would be a non-specific deviation? Is that how we would handle it? Or just handled outside of the child support worksheets? I mean, did she give any direction on if we remove it, the best way to handle it, or what other states maybe are doing that works well?
But she did say that most other states treat it like we treat uninsured medical expenses. That you share it outside the worksheets in some sort of proration or by percentage. And I will say, as a practitioner, I would say that's what I see most commonly these days. And I will say that I think we have even more need to make sure that's a clear option, which I don't think it's a clear option in the way our guidelines are currently written. Given the parenting time adjustment and the sharing of expenses on the broader scale that we are seeing implemented now, and will, be that much further implemented come January 1st of 2026 when the parenting time adjustment goes into effect. I think we're going to see more and more of this. My recollection is, and I know we've got people here who can speak to this, is that, anytime we're doing something, quote, I'm using our big air quotes here, outside of the worksheets, DHS gets anxious about that, because that's never their ideal way to do it in terms of child support enforcement and that kind of thing. So I would, just brainstorming it and knowing, what I expect to hear from them, although I know certainly Mr. Cuthbert's here and Regina Quick just logged in. So they may disagree with me, but my understanding is for the purposes of those agencies and child support enforcement cases, they like having the option to keep it in the calculator, so they get a one amount. But much like several of the other things we do, like work-related childcare, I think we have every opportunity to let it happen both ways and leave it to the discretion of the court, who can then say, in this circumstance, I don't want it to be handled outside of the worksheets. This is how it's going to be done, so that child support enforcement doesn't have to deal with that extra step of collecting percentages going forward. But for the majority of cases, doing it as a percentage above the monthly base support, just like we do uninsured healthcare expenses, I think would serve Georgians the best. That's my opinion on it. And Dr. Vernor supported that. I think I feel comfortable saying that was my takeaway from what she said as well, at being that economic expert.
Yeah, that's what I remember as well, Katie. She was saying that some of the states handle like the work-related childcare like they handle the health insurance premiums, and kind of like how we have that option as well to handle it outside of it. I think, because my concern is that is what I see the majority of people do anyway, particularly in mediation, both with practitioners and pro se's. There's some agreement as to how it's going to be done. Oftentimes there's a cap for extracurricular. And I know the worksheet, I think there's a spot in the worksheet for it. So if we left that there, then I would say remove the 7% and just let them fill it in as some kind of deviation or adjustment, whatever, on the back end, so that then it's accounted for. Maybe that would make the DFACS happy as well, DHS and their enforcement. But, for the most part, 95% of the time, it is a discussion that goes into an order about what's going to happen with extracurricular activities.
Right. I agree with that.
Regina, any thoughts?
Well, I'm not speaking on behalf of the agency when I say this, but I will say that allowing some clarity here and allowing people to do what they ordinarily agree to do about these extracurricular expenses, it is the one area where parents seem to agree. And then you start saying, well, we can't do it that way. We got to calculate first this 7%. We got to do the whole worksheet. We've got to see what the number is that's embedded in the basic child support obligation. And then you can split it the way you've agreed. And at this point, then you've created an issue and discussion where there was absolute agreement usually between parents about these extracurriculars. So, I don't know what the division's position on that will be. I doubt it's a discussion that they have. In that context, it will perhaps, if you take it away from being a deviation and being embedded in, then it may affect the amount of child support. I don't know. I just have to look at that. But certainly from a practitioner standpoint, this makes perfect sense and removes a very common reversible error that happens that really is, it's a trap, right? It's a trap for the unwary when judges are trying to talk to parents about something they've agreed upon.
And we have seen that in several cases that have, there's been these things that are done, but it didn't account for the worksheets, and it was done outside the worksheets, and that is reversible error.
Judge
Anybody
Cuthbert,
else?
or Colbert, excuse me, Judge Colbert, what are you seeing?
I know, I agree. The 7% is something that has baffled me, and I don't hear any practitioners on my court speaking of that. In fact, they usually do agree on the extracurriculars and how to address it. So I am in favor of foregoing the 7% and letting that continue to be something that can be worked out outside of the actual calculation of support. Plus, it fluctuates so much that I just think it makes sense to do.
And when the division is before me, I don't ever hear them arguing about extracurricular or special. I mean, it's just so rare that you hear that from them. It's usually the private cases where I'm hearing it. Judge Key, glad to have you here. Nice to see you. You look refreshed. And like maybe you've been in the sun some, so.
I mean, Key Largo, the good news is this gives me an excuse for my wife to keep our 2 young grandchildren out in the sun where they feels like temperature's 100 degrees, and I get to come in here and do this meeting. So
Oh,
thank you for the invitation.
Yes, we're always happy to see you.
Yeah.
Well, anybody else have any comments, concerns, recommendations regarding removing the 7% test and the deviation for special expenses?
Judge, I'll just say I wholeheartedly support this. I agree with everything that's been said. I think this is something that we need to do. And so I appreciate the subcommittee working on this.
Well, we appreciate you being here and being a part of this. And honestly, the more we can simplify it, the better, I think. I mean, we have to do it right, but also if there's no need to complicate things, then why would we complicate things? And I think this is one of those things that's been complicated for a long time. And what we found is when it's complicated, people don't do it at all, or they don't do it right, and then it's reversible error. So, I always feel a little bit weird when I say something like this as one of, 8 or ever how many are here today, making recommendations for, something that's going to affect many thousands of children. But I just don't see any reason why we would not recommend some changes, or at least present to the full commission that we're recommending some changes to the statute regarding removing the 7% test.
Well, I'll just note, I've been thinking about this a lot, and to your point, I think it's confusing for clients often who maybe are negotiating this, could be negotiated and then ultimately it's submitted. But maybe your negotiations break down, then you have to try the case, and it's a totally different consideration to be presented in those circumstances. I think extracurriculars are distinguishable from medical, because if you're splitting medical, that's prescribed by a doctor, and you're doing what the doctor says. The difference, I suppose, on education is or on extracurriculars, that there's greater discretion for the parent, and what that could increase costs, which is often addressed with a cap of sorts right now, because that's being negotiated. And so maybe an issue would flow from this, because we're really talking about a contested case, I suppose, where, okay, well then is a cap going to be available, or what are the protections there? At least in my mind, I'll save that conversation for a different day. This is about the 7% right now, and I think it needs to go for greater clarity.
Well, and I think that's where a judge or jury decides. If you can't decide and you can't agree and you can't settle, then like everything else that judges and juries have to decide, that's one of the things that judges and juries have to do. But all right, so then we'll just, at the next full commission, we'll let the commission know that the subcommittee has met on this, and is there anybody here opposed to that? And just let them know that we've discussed it, and that the subcommittee was in agreement that the 7% test needs to be removed.
And I would just add, Judge Williford, that I think it's a little bit more than removing the 7% test. I think it's taking that next step and saying, because courts have been dinged with reversible error for doing it. I think I think we need to add language that says that the parties are free to agree and the court has the discretion to order, fact finder has the discretion to order, a sharing of those expenses in whatever percentage agreed upon or ordered. I think we'll have to, because I think that's where some of the appellate cases come in, is whether or not that discretion even exists, even where they are agreeing. I think people are agreeing and doing it a lot. But I think on the cases that it's gone up, that's where we've seen some reversible error, because the appellate courts have interpreted our current guidelines to say that might not really be an option that the court or fact finder currently has.
Judge Key?
I know our commission meeting's just a couple of weeks off. Would there be any chance we'd have something to look at by then? Something specific to look at, language?
Joanna?
Yes, Your Honor.
Is there something specific that we could have for the commission on this issue by the next meeting?
Yes,
Okay.
I believe so.
All right. We will plan on working on that then.
You mean the proposed language?
Yes.
Okay,
All right.
certainly.
And then has that agenda has gone out already, hasn't it?
When it came to me this morning for approval.
All right. So we may need to add that if it's not on there.
Yeah.
And I guess moving into the next topic, it's similar. The extraordinary expenses being handled outside of the worksheet. And
Right.
Noelle, I know you've talked to us about this several times.
Right, adding provision to the statute, very similar to how work-related childcare can be included on Schedule D or handled outside of the worksheet. I think it's a very similar issue because those expenses can fluctuate wildly. And in the case of the extracurricular, I've been saying they can fluctuate on the whim of a child even, like, they want to do horseback riding this year. They don't next year, whatever the case may be. So, yeah, and I can work with Joanna. It's going to take that there's an interplay of those first two issues, the removing them, the 7% and the handling of the extraordinary expenses for child rearing outside of the worksheet. And it's going to take removing some statutory language and adding some new.
And I guess that's sort of what I was saying a minute ago. I was jumping ahead of you, Judge Williford, and saying it's remove the 7% and make some language clear that it's discretionary. That's really item 1 and 2 together.
Like we did with the work-related childcare.
Exactly.
And so would we have an option then to, like we do work-related childcare expenses, to include it in the worksheet or handle it outside? Is that the goal?
Yes, and what I'm thinking is that it would continue to remain a deviation on Schedule E for those who want to handle it inside the worksheet. And then there's a way that I'm just like work-related childcare is on Schedule D. You can handle it inside the worksheet or you can handle it outside. So those, trying to make everybody happy simultaneously.
But right now, handling it outside the worksheet, since the statute doesn't allow for that, creates a problem. So we would just need some changes. Well, it's silent on that, right?
It's silent on that. And what the Court of Appeals has treated it as a deviation, which is great. And so as long as it's justified, and I think it's very justifiable, it can get approved. The waters got muddied significantly just about a year or so ago, though, when the Court of Appeals specifically rejected an agreement of the parties on extracurriculars, saying there was no justifiable explanations, the findings of fact, and they didn't include the 7% test. I personally don't think that's necessary. And I think that Joanna and the subcommittee and the full commission can also perhaps look at the wording of OCGA subsection C6 that directly addresses agreements of the parties. I think it could be better worded. It fully allows, agreement contrary to the presumptive amount of child support. But then it goes on to say, but if it's not justified by deviation and is different than what the statute would have, calculated, it should be rejected. So the Court of Appeals said, well, you didn't apply the 7% test, so we're rejecting this agreement. But that was the point of that provision. That was the point of allowing an agreement outside the statute, is that it's not going to perfectly match what the statute would say. So I would specifically
So
recommend.
are you saying the Court of Appeals got it wrong?
Yes, thank you for asking me that direct question.
Yes.
And I think our statute could be clearer. I mean, it's hard. It says if they've deviated, if they've agreed to something outside of the presumptive amount of child support and failed to justify it, then it should be rejected. It's both of those things. But they just said, oh, you didn't do the 7% test, this is rejected. That's an absolute nightmare, to Regina's point. These things are routinely done. They give families flexibility. Folks are agreeing to these things, and then the courts are going out of our way to say, no, you're doing it wrong. So I don't think anybody really intends that. Also, just by, Lazaro, would you please promote Sarah Austin? Are you trying? Okay. Sarah, if you're on, the Zoom's going to prompt you to accept a promotion, and you won't be able to speak until you accept that. Also, so it's a banner day. We have full membership at this meeting, which is so fantastic.
I am buying a lottery ticket on my way home.
I was going to say, I don't know that that's ever happened since I've been in.
I don't think so either.
No,
I am buying a lottery ticket. And just for anyone who wants to, be nerdy about it, and I don't mean that in a derogatory way, the case that comes to mind, I think this is what Noelle was referring to. It's Wiggins versus Rogers, and it was in the spring of 2023. It was a Cobb County Superior Court case that the Court of Appeals sort of turned around, among other things, because of this extracurricular activity issue. And I've actually heard Judge Hill, who was the trial court judge on the issue, speak on the issue since the Court of Appeals reversed her on it. And frankly, I got some phone calls. Hey, Katie, what the heck are y'all doing? Look what our guidelines did. And do you think, I thought I was fine. And I'm like, Judge, I agree with you. I think the Court of Appeals maybe missed it on this one. So I think maybe clarifying that this option absolutely should exist. And by the way, this case has not stopped, now that it's been 2 years, has not stopped lots and lots and lots of people from doing it anyway. They're just doing it under the radar. It's just that we should make it so that they can do it and not have to worry that someone's going to change their mind and get it reversed on appeal. Because this did start with an agreement of the parties. So let's fix it.
Yes. And if I may, Judge Williford, do you mind if I just briefly share my screen to show you the statutory section that I think?
Oh, of course not. Go ahead.
After the heart of this debacle, are you seeing that?
Now we are, yes.
Okay. Perfect. So I can't get rid of the participant. Okay, so it's here. It's this C is above, but it's C6. Nothing contained within this code section shall prevent the parties from entering into an enforceable agreement contrary to the presumptive amount of child support, which may be made the order of the court pursuant to review by the court of the adequacy of the child support amounts negotiated by the parties. I think we all think, fantastic, right? Let the parties come to their own agreement. Barring, however, like with judicial oversight, that somebody hasn't been coerced or there's no abuse, somebody hasn't been, agreed to a $20 child support order. I think that's what that's getting at. But it goes on to say, including the provisions for medical expenses and health insurance, to make sure the parties are remembered those things. Now, here's the problematic part in my estimation. Provided, however, that if the agreement negotiated by the parties does not comply with the provisions contained in this code section and does not contain findings of fact as required to support a deviation, the court shall reject such agreement. And that's what the Court of Appeals hung its hat on when in Wiggins versus Rogers, versus Rogers, right? Okay, Wiggins versus Rogers, to say, well, the agreement about the extracurriculars, just dividing them 50-50 when they occur, doesn't comply with the 7% test of all things, the thing that nobody understands. So can you imagine trying to get the parties to calculate 7% of the BCSO and reducing the deviation amount and all of that jazz? So these things, these two issues are sort of bound up hand in hand, the 7% test and handling the extracurriculars outside of the worksheet, but also that proviso in C6.
Well, I mean, to me, it's almost like you pointing that out almost opens another can of worms for me, because now I'm like, C6 is an issue for me, because the first part of the paragraph is completely opposite of what the second part of the paragraph says. I mean, you can make your own agreement if the agreement is what the child support worksheets say. Is that not what it says?
That's what's
mean-
confusing, and I think there's a way to read it like that, which is what the Court of Appeals did. I think it's meant to say if you go against the presumptive amount of child support, to agree to something outside of the worksheet, it just needs to be fully justified with the findings of fact. It's if it does not comply with the code section and does not contain findings of fact. So it only
Well,
gets rejected if
I was
those-
going to say, if it meant what you said it meant, then it would be the first part, and it would say, provided, however, that it contains finding of fact required to support a deviation. But instead it says, provided, however, that if the agreement negotiated by the parties does not comply with the provisions outlined in this code section and does not contain findings of fact. So what does that mean exactly? What is complying with the provisions contained in this code section?
Exactly. It fights against itself, and that's why I raised it. I think we need to give a good hard look. I know what I've thought it's meant all these years, that the parties can agree to something other than the presumptive amount of child support, and the court should quote unquote should in general approve those, barring some, unless they're not justified by the findings of fact. But that's exactly why I raised this. This is causing a lot of trouble.
And the thing is, I agree with both of you. I could read it Noel's way, that it's if it doesn't comply and it doesn't have findings. So if it doesn't comply but it does have findings, the court should accept it. But I also agree with Judge Williford that you could easily read it and say, if either one of those is the case, because then you get the last clause of it, the court shall reject the agreement. And that's obviously that's where the Court of Appeals hung its hat in Wiggins versus Rogers, is that it said that the trial court was required to reject it. So
and thank you, Katie. And I wouldn't say it's Noel's way. It's what I think the original drafters were intending to do. Allow the parties to agree, but give some judicial oversight. They can't go completely off the rails, but to allow flexibility. But I just don't like the wording. And I think this was in the original bill. It's been here a long, long time. And it's suddenly a hot topic, especially around extracurriculars. So I don't have any ideas off the top of my head about how to reword it, but I have also talked to some, especially judicial staff attorneys, Superior Court staff attorneys, who are just in the trenches and like pulling their hair out about what this means. I want to help those folks out, and judges for that matter. So can I I'm adding to Joanna's plate. We need to do the first 2 bullet points on this agenda, but then also I think take a good look at rewording that so it's just crystal clear.
C6, because it's part and parcel of the problem.
right.
Yes. Yeah.
But is everybody in agreement? The first 2 bullet points, they're removing the 7% test, and the extraordinary expenses being handled outside of the worksheet, or the option to do that. Those both need to be looked at. We need to draft some language to present to the commission regarding both of those 2 things. And while you're at it, if there's anything in C6 that complicates that, then we need to fix that language as well.
Yeah.
I'm in agreement.
Yes, in agreement.
Any other comments on that? All right, so once again, the hard work and the heavy lifting starts with the staff, and then we'll go from there. And that moves us to Katie's favorite subject since she apparently represents all the wealthy people in the state. High income deviation, Katie.
So as y'all know, in our most recent legislative endeavor, among other things, we we increased the BCSO table to account for an extra $10,000 a month in gross income. We were lobbied hard to do even more than that, and it came down to a cost benefit analysis. I don't think anybody was just theoretically opposed to having the BCSO table go out to infinity. It's just that there's an expense associated with it, and we have to be mindful of how many Georgians it affects. And so we did the extra $10,000 and stopped there. However, even in doing that, I routinely get questioned about why doesn't it go out further? And I can say, in my experience, I don't know that I represent only wealthy people. I certainly don't represent all the wealthy people. But certainly it is not at all uncommon for me to handle cases where one of the parties makes more than where the BCSO table currently stops. And I can say, at least anecdotally in my experience, the courts are not inclined to entertain much, if any, about a high income deviation. So I would say it's an underutilized deviation, even with respect to it being a small percentage of the people who would be eligible for it. Of the people who are eligible for it, it's still, in my opinion, underutilized. I actually had occasion to be on the phone with, or on a Zoom with a divorce lawyer in North Carolina and New York at the same time recently, and we were discussing this exact issue. They both have deviations like we do, high income deviations, and it was interesting because I opined that Georgia doesn't routinely utilize the high income deviation. North Carolina said, yeah, we see it, but not often. And New York said, oh, our judges lean right into it. They have no problem with it. They use it all the time. They don't stop where our table stops. They routinely go above for people where their financial circumstances warrant it. Even though it sounds like, I've not studied their language, but it sounds like their language isn't all that different from ours, because ours is still an open-ended deviation. We just don't use it much. So, as I said, we've been lobbied. I think most of you probably remember hearing from people that asked us to go to do more, 2 years ago when we were last looking at a bill. Basically, we're still being asked to do more, and I would leave it up to y'all to decide if at this point we want to take this on, and if so, how would we do that? Would we provide guidance about using the deviation, or do we try and do more with the BCSO table and draw it out further, or leave it alone because we did just make a change? I suppose any of those things is an option.
Well, I mean, that's my gut reaction, and we literally just went through all this and decided we were going to go up 10,000. Was it 10,000? What did we go to, 40,000? Or
that's right.
And here we are. It's not even, did that begin July 1st, or does that start
July 1st of last year? So we're in month 13 of having it out to 40.
And we're talking about changing it again. I mean, I think that I have no idea what the percentage is of people who fall in that category, but I know in the scheme of things it's not a huge percentage, and those are what good lawyers make great arguments to judges about, and but that's just my opinion, one of many. Anybody have any comments, opinions, thoughts?
Judge Key?
So Katie, if there were a change, what would you want it to look like? What do you think it should look like?
So I would want to know, before I offered an opinion about that, I would want to know how expensive it would be to draw the BCSO table out even further than the 40. Because, if we did that, and if that were not outrageously expensive and something that we could do in a way that's reasonable, and I don't know what the reasonable number is, but then we're that's addressing it without having to do a whole lot to the actual language of the statute and without having to try and craft guidance for beyond what is currently in there about a high income deviation. It just, it just moves the high income part even further out to an even smaller percentage of Georgians, who have to make more than the next threshold. But I have no idea as I sit here, and I don't know if staff knows, but I don't know how expensive it was to go from 30,000 a month in gross income to 40,000 a month in gross income on the BCSO table. So, I know we did it recently enough that somebody ought to be able to figure out roughly how much that cost to get there. But that would be my first question. And if Noel or Kurt or somebody knows the answer, and if it's some astronomical crazy number that would cost the taxpayers to even have the economic work done to do that, then maybe that might influence what I would recommend, I guess is what I'm saying. Does that make sense? Does anybody have any idea what that work looks like and how much it costs?
I think it was just rolled into Jane's, complete contract amount for the economic study that she was
I mean,
charged
I'm sure it was.
with coming up with the revised numbers per the, economic factors,
Right.
and extended the table to 40,000. I don't remember cost being an issue around why we stopped at 40,000. It may have been Jane herself who said the number of cases that exceed combined adjusted gross incomes of 40,000 are so few that she just recommended stopping at 40. But I don't think, it's not my recollection that it had anything to do with like she was going to charge us more for doing 10 grand more or 10 grand more. I'm just out of curiosity, where would you think it should stop at, like 100 grand a month or?
Well, I guess that then I would ask the next question to Jane, which is because I think she would have these stats, fairly readily available to her. That's my impression anyway. I'm not trying to speak for Dr. Benor, who's, not here, so that's not fair to her. But, I would think she would be able to tell us what percentage of Georgians, are impacted by that. I feel like
She did.
I thought she did.
So what I remember, because I was looking for my note, I
Right.
could have sworn, I think at the last meeting, she said from the 2021 sample, 1% of cases had monthly incomes greater than 30,000. So it was
Right.
like 277 cases. So it's not a lot. It's a really, really small
Right.
number. Which I think, so I would kind of agree with Judge Williford. I feel like we just handled it. I would say to table it for now and let, the courts continue to have discretion over it, or the parties to have discretion over, what happens beyond the 40,000, because it is just such a small number. So if it's 1% that had greater than 30, then we're talking a much smaller percentage, a 0.5%, a 1/4% for 40 and above on a monthly income. And it's just a small number.
Yeah, I tend to agree with you guys. And of course, Representative Estration is with us, and my experience has been that legislators don't have the appetite to address similar issues every 2 or 3 years.
Well,
So-
I agree, Judge, and to Judge Wilford's point earlier, because we just took this up, I think it would make sense to give it some time and for us to, I guess, consider proposal maybe for the future, but not right now.
Kurt, your hand is up.
Thank you. I was just going to say that the 2026 economic study is about to be kicked off, so we may get some samples where we're seeing income, higher than 40,000. Who knows? So, but we'll know shortly.
I wish it were my problem. Although we do appreciate the
Ditto.
Supreme Court judges' raises. No, Noel?
So like a middle ground on this, maybe to do some training and education about it, because I will say it is the only topic that I've had a judge stop twice now and call me directly on the phone to say, now what do I do? Because it's just very scant, even equally scant or less scant possibly than the parenting time deviation, which is just give a deviation and there's no guidance. And so I think our guidelines are so tight and really prescriptive of how you handle things. And it was just like, oh, if they exceed the BCSO table, give it a deviation in the best interest of the child. And so it's really important for judges to understand what you definitely do not do, and this is what I've said on the phone to two of them, is if somebody's at $50,000, you don't take the BCSO amount for $40,000 and the BCSO for $10,000 and just add those together. it's difficult to fully explain the economic underpinnings of that, but it's not a direct relationship. The amount at which a family continues to spend more and more on a child finally stops. I mean, you're not buying your child 50 pairs of shoes just because you can. You finally just buy yourself a nicer car or go on more vacations, so there's just some economic underpinnings to that I think maybe staff could work on, including in training or explaining to people in general. That might be like a happy medium for right now.
I agree with what Noelle said, and I will echo that. I get asked about it very regularly. I mean, I speak on child support, and I have judges and lawyers call me about it. I mean, many times a year. I would say at least a dozen times a year I get calls about it. So I get that it's a small percentage of people, and maybe that's because those are the people who can afford the lawyer who's going to be digging into it, to Judge Williford's point, and going to make the argument. I mean, I'm not saying that's not why, but I get asked about it nearly every time I present on child support, and very frequently it's a judge who's saying, help me understand what to do when I have this case in front of me. And maybe, again, circling back to Judge Williford's right, maybe that's because that's when the judge has two good lawyers standing in front of them, arguing two different things. But I get asked about it a lot.
Well, I mean, I haven't had a lot of them, obviously, in Macon-Bibb County. I do have one right now where the assets are in excess of 50 million and they have children. And what I'm interested in is, what have y'all been spending on the children? Like, what is their standard of living kind of been, and what have their expenses been, and how much does their private school cost, and what activities are they in, and how much do you traditionally spend on their clothing, and all of those things. Y'all can afford to do it. Let's let them sort of maintain that lifestyle. And I'm not gonna say, all right, now the children are going to live in a $300,000 home when they're used to living in a, $20 million home, so I just kind of look at that. But again, you have these, I'm sorry, when we're dealing with cases with those kinds of incomes, they're not pro se litigants. They're hiring the top family law attorneys, and they're coming in and they're proposing things to the court. And that's what judges or juries do, is they take in the information and they make a decision. And at some point, you just have to say, all right, this is where it stops. Right now it's $40,000. Maybe it should have been higher, but we just addressed this last year. I just don't see it as, it's 1% of the population. I just don't see it as a pressing issue right now. In my opinion, is to leave it alone for now.
And I will say, I can get on board with that. And I'll tell you what, like I said, I get asked about it a lot, and I'm happy to report, hey, we have discussed it, and we've discussed it again. And we've discussed it since January 1st of 2020 or July 1st of 2024, when it went up to 40. I feel like I've done my job just by bringing it to you, but I just want to put out there.
Just say, make your argument to the judge or jury if you can't decide.
Right. I will just, in that same category, so we'll put this in the category of making my record. The current language of the high income deviation in the statute does have one thing that I think is maybe not exactly what we intended, but maybe it is. But it says, under specific deviations, to capital A, for purposes of this subparagraph, parents are considered to be high income parents if their combined adjusted gross income exceeds $40,000 per month. I actually had a case where an opposing counsel, they were at over, this was actually when it was 30, but the language was the same. So it was combined adjusted gross income. Neither one of them on their own made above $30,000 per month in gross income, but together they did. And the custodial parent's lawyer was arguing that the non-custodial parent should have to pay a high income deviation because their combined income was over $30,000 per month. And even when it was first said, I was like, what are you talking about? You're going to charge the guy because together they make more when he alone doesn't hit the limit? And he argued it. I mean, good news is the judge didn't buy it, or good news in my opinion is the judge didn't buy it. Guess which side of the case I was on. But I do find it weird that that the combined income, when usually we're thinking about one parent having that kind of income, because then that parent would be the one that could potentially be subject to a high income deviation. So if we were inclined to a cleanup bill, I would say that could be some language that, might at least, but I'm not trying to open a can of worms we don't need to, and we all know that can get scary when we're doing that. But that would be the one thing I would point out.
Well, I don't have any problem with us looking at that just to see if there's a word that needs to come out that shouldn't have been in there, or that makes it confusing. But
I mean, if I hadn't read it to you and I told you that it was combined income as opposed to one parent's income, doesn't that sort of go against your just sort of logical thought process about it? Is that it wouldn't
Yes.
kick in unless one parent had that kind of income?
yes.
Yeah. So
So I'd be interested in looking at that further to see if there's an error. It sounds like, potentially, but I read something before and thought it was a clear error. I thought, I have found this error and this is so wrong. And I called Noelle and she goes, no, you're reading it wrong. Read it this way. I don't even remember what it was now. So, I'd have to look at it, but yeah, I'd be interested in looking at that. Joanna, would you mind jotting that down as something that we need to look at?
Sure.
All right. If there are no other comments on that issue, if we can move on then to the dental and vision issue. We've talked about this a lot, and I've always been a bit confused as to why we didn't add the dental. I mean, children need dental insurance, certainly, vision insurance. And when I was a practitioner, I'll just tell you, I added it anyway. I lumped it all in and said, this is how we're going to do it. I never went to Schedule E. But there was some concern raised that the reason why we did it that way was, Noelle, what was it? The federal law or something? Or was it
I'm not even sure. I mean, because this
Pat
is
raised that? Maybe Pat is the one who said the reason why we had to do it that way was because the federal law. Does this ring a bell to you, Judge Key, or you, Regina, or Katie?
I can't remember.
Yeah.
she
It
may
was
have
something about the federal law required
medical,
the health
but not.
part, but
It
then
was
the
something
dental
like
and
that.
the
Yeah. I just don't remember the specifics, but someone, I think it was Pat that mentioned it.
Yeah, so it is if health, that language that's in the code about if it's available at a reasonable cost, and if the division folks are still on here, they can probably speak to it better than I can, but it is required that we seek out that information, and if even if it's not being provided at that time, if it's available at a reasonable cost, we're to seek an order for it. We meaning the division. That's at least what I believe to be the case. And that was probably the reason for the dichotomy. The problem I always found as a practitioner was that there were many plans where they were lumped together anyway. There wasn't a separate coverage. There wasn't a separate premium attached to the separate coverages necessarily in some plans. So
I haven't ran into that as much as I've just run into, if parties have the ability to provide dental or vision. I certainly see dental more than vision, but both really. And vision insurance is so inexpensive that, most people who have that ability do add it. If they have the ability to provide that for their children, they provide it. And what I have seen happen with Schedule E is it's treated all kinds of different ways, but sometimes you get like a dollar per dollar sort of deviation instead of the pro rata share. I mean, it's just been a mess to me. I've never really understood it. And when I raised this, and I wish my memory was clear on exactly what Pat said, I thought maybe she even sent us a memo on it, but there was a reason why. I guess Pat was the staff attorney back in the day when y'all originally wrote this bill. Does that sound right, Judge Key? But there was a reason that she explained why it was done, and I'm not sure if I ever truly understood the reason, but the question is just, is it necessary to put it as a Schedule E deviation? Why can't it be on D with the health insurance? I mean, it could be a different line, health, and then dental, and then vision, and then childcare, or whatever. But is there a reason why we don't treat it that way, or why we couldn't treat it that way?
I think that's how it ought to be treated, especially since our definition of uninsured medical expenses that are to be shared in proration includes orthodontia and
Always.
dental. And, so it's really to the advantage, I would think, again, this is just sort of, I would think the only thing we would need to be mindful of, and I don't think this is what we're suggesting, but is that I don't think we want to create a requirement to have dental and vision insurance, because it's not always offered, although I tend to agree with you, Judge Williford, it is generally inexpensive, but easy for me to say sitting where I sit, and sometimes to quote Regina Quick here, things look different depending on where you're sitting. But I think to treat the premiums when they exist the same way that we treat health insurance premiums when the uninsured expenses, whether it's because they're just uninsured, but there is insurance, or uninsured because there isn't that insurance, in a uniform way, just makes sense to me.
Well, there's nothing about the worksheets that are requiring it. It's just saying, if you have this expense, this is how it's broken down between the parents.
Right.
Judge Williford, I really like your idea of a separate box on Schedule D. I have had the same experience where you get a pro rata split for the health insurance premium, but it's a deviation goes dollar for dollar to one party. And so I think that's a good idea. And sure, if either there's no dental insurance or there's no cost for the dental insurance, that would just be a blank.
Yeah, I agree. I think moving it is probably a great idea. My only concern, I wonder if we need to talk to Dr. Venor, if that's a Venor question, about why it is the way it is currently, since we all remember that there was some talk about something federally related to those two things. So that would be my only.
Well, I'm going to look back in my emails, because I bet if Pat sent us something, she emailed it. And I'm just going to do a search for years and see if I can find in maybe my old notebook, and see if I can find anything, or reach out to Pat. But I just, I don't recall her saying, no, we can't do it that way. I just recall her kind of being, I don't want to say defensive, but at least explaining why she thought we needed to understand why it was done that way.
And
Byron, you turned your video on. Does that mean you have something that you need to?
No, I was agreeing with you all. In my head, because I remember, I think she just emphasized it because the feds were talking about medical at the time, and like you said, I think that's why it's done. But I'm not sure.
Anybody opposed to proposing, at least presenting to the commission, which is what this subcommittee does, that we advocate for in our cleanup bill, I guess we're calling it, that we make changes to change our Schedule D to make a line item for the dental and the vision, so that it is no longer a Schedule E deviation, but an adjustment on Schedule D. Does anybody have a problem with proposing that to the commission?
I mean, I certainly think it's worthy of that full commission discussion, that should vision and dental insurance, if ordered or obtained or, maintained, be a mandatory adjustment in the same way the health insurance premium is. I think it's, that's a very different thing, as you have said, than saying that you do the same level of scrutiny and inquiry as you are required by law to do on health insurance. That's not what we're saying. We're just saying if it is an expense, should it be a mandatory adjustment? The subcommittee says yes and submit it to the full commission.
And, I hate that we didn't get to this topic last year. We talked about it so much, and we have, people have been working so hard to fix the calculator to do what we have now asked it to do. And now we need to make other changes, but we just simply ran out of time last year in spending so much time on the low income adjustment and the parenting time adjustment that we had to shelve these other issues. And hopefully it's things that if we do get those passed, changes that can be made quickly and not changes that would take, 18 months or whatever it's taken for IT to work on the current changes. All right, so those things then, it sounds like we're in agreement on these issues, Katie. The possible recommendation to the Child Support Commission to amend OCGA 19.615, that we would recommend to the commission that, well, I can't say what the language is going to be, but we're going to work on some language to recommend to the commission about the removing the 7% test and the deviation for special expenses, making an option to have the extraordinary expenses handled outside of the worksheet. We're going to shelve the adding more guidance to the high income deviation for now, and also recommend moving the dental and vision insurance out of Schedule D and into out of E and into D to be included, not included with the health insurance, but having potentially line items for those things on Schedule D. All right, so that moves us then to the advisory opinion on parenting time adjustment and modification. I did read the memo on the advisory opinion. Again, I was not here at the full commission meeting, but I do remember talking about this some at the last subcommittee, and I thought we kind of decided advisory opinions were not going to be something that we did, but I guess there was a memo that went out, if I read it correctly, sort of understood that we probably can't or should not, or did I read that wrong?
That is one interpretation of you could circulate, you could educate the judiciary and the public on whatever you wish and maybe not call it an advisory opinion, but that is generally the gist. Yes, ma'am.
Yeah. I don't have any problem with that. I guess the reason it came up was because there was some concern that since we didn't specifically address whether or not these changes, i.e., say the parenting time adjustment, qualifies as a material and substantial change in circumstances justifying a modification of child support. We kind of were silent on that we were going to get a lot of questions on that. Both the judiciary, attorneys, the commission, everyone were going to kind of get blown up with questions about, does this justify a modification, the fact that we've moved to a parenting time adjustment or a low income adjustment or these changes that we've made. And I think my position was that yes, it does warrant a modification. And then, but there was a question about whether or not we should have probably included that language in the statute, or whether or not we could sort of post an advisory opinion, on the commission's website that says, for all of you who are asking, yes, this does, justify a relook or a modification potentially. So if we can't do that, then I guess how do we answer that when we start getting those questions? Noelle, is there any language in the statute that guides us on that question?
Just the already existing provisions on modification, and that it's just like any case, it's going to be up to the judge's discretion about whether it qualifies as a modification. I do know, yeah, Joanna likely will get those questions. I'm sure Katie already has been and will get them. They came up, I faced them when I was asked whether the change in the BCSO table qualified as a reason for modification. So it comes up. I think back then I tried to very delicately just say, there has been no changes to what qualifies as a modification. I think I left it at that. Which was true.
That's such a Noelle answer. I mean, it really is.
Because the commission didn't advocate for a change in what qualifies for a modification, so it's just going to continue to be on a case-by-case basis, and we didn't come out with any across-the-board guidance. And again, in this, it could be seen as the same way, right? There could be some cases where somebody has a minimal amount of parenting time, like 10 nights or something. And so the parenting time adjustment is going to be like 33 cents or so, whatever, or $5. And so, but there are going to be times, for instance, when a non-custodial who has the child 50% of the time didn't get any parenting time deviation. So there's no accounting for that. And it would be a sizable adjustment.
So the way I read the advisory opinion, and this is sort of the way I saw it when we were, kicking it around at the commission meeting, is there's existing case law that will have to be applied in this context by judges to make this, and, trial judges and appellate judges that will have to make this decision. The one thing we could do, if we were so inclined, is we could certainly post a link to those cases in without comment, without comment as to how it will apply, because your case is different. Every case is fact specific as to how that will be interpreted. I think that's about as far as we could go if we were so inclined.
Who's hosting this? Can anybody mute Judge Key? I think he forgot to mute himself, and he
Thank you, Lazarus.
Judge Wilford, you're muted if you were speaking.
I was saying somebody mute Judge Key, and I didn't realize I was muted. Okay.
I had to help with my grandchildren with something. What did you need?
We muted you because we were listening to your phone conversation.
Oh, well, it's not a phone conversation. It's my granddaughter. Just got sent up here. Got sent up here with an injury. I'm trying to
Okay,
help
well,
her.
I hope she's okay.
Yeah, like I'll mute myself this time.
That's okay. So, Regina, posting on the commission website links to what again? I'm sorry.
No, I was just saying, if we were so inclined, and I'm not saying we should or we shouldn't, the furthest we could go is to take these cases and these principles that were being discussed in general at the commission meeting, when we were discussing this notion of an advisory opinion, and post it as an educational shortcut, if you will, to practitioners so they can understand what to argue or what the considerations are. If we want to be helpful, to people that are being paid to represent their clients. I don't have an opinion about that. To me, it's for the litigants to raise in their factual cases, and not for us to weigh in on one way or another as to how this is litigated or how the appellate court should rule once inevitably they will be presented with the issue, right? Somebody's going to present it to them.
I think we're going to see, for sure, there are going to be trial courts having to deal with it very early on, like January of 2026, if I had to guess. And then, yeah, I don't think it'll take long before it to hit the appellate courts. You know, obviously, whether they care to tackle it or not will be up to them, since we don't have our pilot project anymore. But I think we'll hear about it, you know, as quickly as the system would allow it to come to fruition.
Well, for purposes today, the answer is that the Child Support Commission is not going to be in the business of rendering advisory opinions. At least, I mean, I guess that's a full commission decision, but that's what the subcommittee has decided.
Yes.
Okay. New business, any other new business?
I sent an email to our co-chairs just a moment ago that I'm starting to hear from practitioners about how this parenting time adjustment is playing out in some of the courts that are telling their lawyers to go ahead and make the calculations and present them. So getting some interesting stories. I actually had somebody do what I asked, and that was put it in an email to me with some worksheets, and I will lift it up so that everybody can see what your concerns are and what your issues are and what the judge has told you his concerns are. So I did that. So that's just an FYI. And I expect we'll continue to hear more of this as the courts are playing around with what's going to be required in January.
Well, I haven't had a chance to look at that yet, but I'm interested to see it. I have no doubt that there'll be some rumblings because it's more work and it's change, and our district court administrator regularly says that he can't get senior judges to fill in for child support days as it is because they don't want to deal with child support worksheets at all, let alone now if they have to do parenting time calculations to include, the number of days in the calculator. So no question, it's, and of course, as y'all all know, we spent years on this and we knew it was not the simplest solution, but decided that it was the best solution for Georgia's children. So it's just going to have to be something that we get used to. But I understand. I spent all morning dealing with an issue for a law that passed July 1st that I'm not in agreement with. So I've been rumbling about that all morning. So we'll just have to keep looking at it. I appreciate you sharing anything that you get with us. And certainly if we look at it and decide that there's some issues that we didn't consider, or we will discuss those at each subcommittee meeting. Any other new business? Katie,
Not for me.
anything from you?
No.
All right. Well, again, I appreciate you all. It is now 3:21, and I think we did break a record by having all of our subcommittee members here. Judge Key, you make sure to mention this to all the other subcommittees that we had perfect attendance on the statute review subcommittee meeting today. And I guess our full commission meeting is that August 1st?
Right.
Friday, August 1st from 10 to noon.
And Judge Williford, if the staff puts it on the executive version of the notes, I'll be sure and mention it.
Okay.
I rely on staff heavily.
All right. Anything else?
If I may, Judge, y'all may already know this, but one of our own Child Support Commission members, Judge Land, has recently gotten the tap to go from the Court of Appeals to the Supreme Court of Georgia. I have no idea how that will impact his membership on our Child Support Commission, but maybe worth putting in on the agenda as a congratulations to him, since our meeting will come, I think, right after his swearing in.
All right, well, happy for Judge Land.
Mhm.
Yes,
Well, I can answer that one, because I just received an email from the governor's office with his reappointment to the commission. So like 5 minutes ago. So, and per the commission's authorizing statutes, it has to be either a member of the Georgia Supreme Court or the Georgia Court of Appeals. So we're good.
okay, we're good. Because
Yeah,
I was
we're
going to
good.
say, it didn't Justice LaGrua used to be with us, didn't she?
She did.
And I remember she went off, but I couldn't remember why. So, all right, well, that's wonderful. Ben Land is a friend of mine. I'm happy to hear that.
Mhm.
All right, well, everybody have a happy Friday. Thank you again for attending, especially on a Friday afternoon. And this will adjourn our meeting.
Bye, everybody.
Thank you.
Bye-bye.
Take care, everyone.